Any mention?
Well, item number 8, that Nokma Council matter will be taken after vacation. Number 8.
Nokma?
Yes, my lord. In the meantime, Mr. Shulai is also not here.
Okay, after vacation. He shouldn't bereavement or something.
Lordship, this item number 8, Lordship, Senior Counsel will be arguing this matter, Lordship. As of today, he is not ready.
8 and 9 is connected.
It's already mentioned just now.
Oh, yes, sir.
Yes, ma'am.
Problem, Lordship.
Yes. Yes, call out.
Item number 1.
Lordship, in this matter, Lordship had directed us to file suggested questions of law in proper format, Lordship. I pray for some time, Lordship. We have not received the signed copy yet. Yes, Lordship.
The copy was with Lordship, but it was not signed in proper order. Lordship has
Lordship.
I don't remember. Anyway,
on the last
Mr.
occasion.
Espandi pays funds allowed for the 2 weeks time to file substantial questions of suggested substantial questions of law.
Lordship, may it come after the vacation, Lordship.
Okay, after vacation. Yes.
Item number 2.
Pray for some time to file rejoinder, Lordship.
Where's the petitioner? Where the petitioner? Who's for the other side?
Mr.
S. Chanda.
Lordship, Mr. Paulson.
Yes. Yadana appears for the petitioner. Mr. Espandi pays funds allowed for that time, for a 3 weeks time to file rejoinder.
Most obliged, Lordship.
Item number 3.
The 3 and 4 for affidavit.
You know, Mr. None appears for respondent.
3 and 4 for affidavit. I'm praying for some more time.
For affidavit?
Yes, ma'am. 3 and 5, sir.
No objection?
Yes, no objection, Your
Yes, sir. Dr. Mozika pays for further 3 weeks time to file.
3 and 5.
3 and 5. Which one? Number 3, 1 second. On call plus. I'm pretty. Number 5 respondents. Who's on for number 5?
Central Board of
Who?
Central Board of Indirect Tax. CBIC.
How can I just I how can they refuse? Central Board of Direct Taxes.
Current refusal.
See behind. Number who refused? Number 5. That's number 5.
It's number 5.
Yes, yes, sir. It's number 5.
398. This is 398.
398, yes. 398.
Yes. What 5? You different.
Item number 3, sir.
What do you given? Number 3. Different cases. How come this one?
Your Lordship, there are 2 different cases, Your Lordship.
Same party, sir. 3 and
Same
5.
party.
398. See, just tell office no mark or something. Actually, you just tell the person who did it. So call my office it out.
We don't know in which case also, 398 or 411.
The Central Board of Direct Taxes is 398.
They'll take fresh up smaller ones.
How will be returned? Yes. If 398, Dr. Mozika prays funds allowed for that time to file.
affidavit.
Well, affidavit stop. It is noted also that these respondent number 5, the service respondent 5 has been returned with the packet marked refused stop. This is not understood as how an authority such as Central Board on Direct Taxes will refuse service. Stop. Petitioners that to take fresh steps within 3 days. Yes, or 3 weeks. How the marking the 5
Item number 4.
Mana boleh apa tu orang? Hah? Masa saya makan ni. Yes.
Your Lordship,
Who's appearing? Where's the?
Your Lordship, they have to come from VC, but nobody is there, Your Lordship.
And for the respondent?
Respondent, Your Lordship, the respondent will be present from VC, Your Lordship.
That's all. Then none appears further. You're supposed to file affidavit. It's the first time it's come. Yes. You are Mr.
D. Das, Your Lordship.
Mr. Didas present on behalf of the petitioner. None appears for the respondents. List the matter applications for affidavits.
4 and 6 is the similar matter, Your Lordship. Much obliged, Your Lordship.
Item number 5.
That is already adjourned. Same order after 3 weeks for affidavit.
5.
That means 5. Something wrong today with that. Huh?
6. Item number 6.
Even noise appeared in the wrong place.
6.
Where's Mr. Das? But it's already adjourned, Matan.
7.
3. Oh, Matan, 6.
So this is also for affidavit. I'm praying for some more time.
Something wrong.
There's a direction to deposit the amount. I have to complain.
1 second.
I complain. Deposit it. 8 lakhs.
You deposit 8 lakhs?
I have deposited. My lord, actually yesterday they opened the portal, but we are unable to file anything. It is very difficult to open. Only that amount that lying, the whole amount, negative balance, that is reflecting. Unless until that will be satisfied, then.
No, but the thing is that now you deposited. When was this?
Yesterday.
Only 8 lakhs. Then
Yes.
this order was passed on.
Yes.
30th of
Yes.
October.
Huh.
So why it took 1 month? When you
And
give
actually,
interim orders that to deposit.
Portal was not opening.
Is that correct?
Portal was not opening to deposit. We are forced to deposit by demand draft. Yesterday we deposited here in Shillong because the portal is not opening. Yesterday evening the SC opened the portal, but it is not functioning.
Since they deposited yesterday only, I'll have instructions for next time.
Yeah. It's submitted by Mr. East House, the consular petitioner, that pursuant to the order of this court dated 30/10/2025, the petitioner had attempted to make the deposit of rupees 8 lakhs as directed. But however, as the portal is not accepting the same, the petitioner is compelled to make a deposit by a demand draft of rupees 8,000.
8 lakhs.
8 lakhs, sorry, dated 28/11/2025. Stuff. A copy of the, what is this? What do you call this? Yes, a copy of a communication to the Asset Commissioner of Central Goods and Services Tax, indicating the deposit as also the number demand draft has been produced before this court today by the counsel of petitioner. So, in these circumstances, learned DSGI is to obtain instructions immediately and to allow to open the, in order to allow the petitioner to recommence his activities. Yes.
Yes, well. Oblige me.
Copy of communication dated 1/12/2025 taken on record
Oblige.
just after vacations.
Number 10 adjourned. Number 10 is still there.
What's wrong today?
Sorry. Item number 10.
Something's really wrong today. What's wrong today? Huh? Majayu.
Printouts are there.
Yes.
My lord, this is relating to payment of interest on the amount deposited by the petitioners during investigation. So the petitioner returned the principal amount but failed to pay the interest amount. So that's why before lordship. And their last date there's stated that there should be some instruction from the Department of.
It's a list of dates. I'm just it's a list of dates.
Okay.
Just for assistance. No more extra. This is the dates.
Yes.
So, my lord, they deposited during the investigation. They deposited an amount of 1,70 lakh rupees. My lord.
Yes.
Now, somehow, though the first adjudication order was in favor of department, confirming the demand of 8,90 lakh rupees something, they filed an appeal before the sestate, my lord. Sestate set aside that.
Yes.
We filed an appeal before this honorable court, set aside. We went to SLP, we came back and filed a review. So ultimately that has attained finality, my lord. Now after that, my lord, they filed an application before the department for refund of that 1,70 lakh rupees. That became due to them, my lord. Now the question at this stage is, my lord, whether they are entitled to any interest or not. Well, I'll just point out two orders, my lord.
This will come to instruction. Now, when was this refund due?
My lord, if I may take your lordship to the first order, page 241.
They deposited this amount 1,005.
Yes, my lord.
Yes.
And then, yes, page, sorry.
241.
Yes.
So, my lord, this is the order in original passed on their application for refund of the amount, my lord. Operative part lordship will find page 244.
Yes.
Page 12, my lord, para 12. I've gone through the records and have caused the Superintendent Tech Ceylon 1 to verify the documents, including the self-attested copy of TR6 Challan so-and-so dated 19/5/2005 and TR Challan, under which amount of rupees 1 crore 70 lakh only was deposited during the period of investigation by the DGCI appears to be correct. In the light of the above verification, I find the application for refund of the amount deposited during the period of investigation by the DGCI amounting to 1 crore 70 only made by Ishan Technologies so-and-so is genuine and acceptable under section 35F of the Central Excise Act, and so-and-so. The refund application is also filed within the prescribed limit. On the basis of the above discussion finding, I sanction refund of rupees so-and-so.
Yes.
So the amount has been refunded to them. There is no dispute on that, my lord. Now against this, they filed an appeal before the
Commissioner appeal.
Commissioner appeal, my lord. That order starts from page 245.
Yes.
Sorry, my lord. That order starts from page 258, my lord. I'll just take your lordship to the last page on 266.
266.
Yes, my lord. Para 18.
Yes.
Going by the above mentioned section 35, the period of 60 days in the instant case would have expired on 13/6/22 if the date of issuance of the impugned order is considered as the date of communication, and would have expired on 5/7/22 if the date of communication is considered as per the claims of the appellant. In any case, the appeal has been filed beyond the stipulated period of 60 days. As such, without going into the matter, instant appeal cannot be taken up. For interest, they filed this appeal, my lord. Now, but that has been rejected by the commissioner appeal.
No, the grounds of delay.
On the ground of
Without
delay.
going into the merits.
Now the question whether they can file a writ petition against this order, my lord.
Yes.
This is clearly an appealable order before the
Yes.
Sestat, my lord.
Mr. Sahu,
Yes, well.
why you have come with a petition?
And but here
Where was the
actually
question of violation? Where can access jurisdiction?
Commissioner appeal, I filed only 9 days delay, whereas Commissioner appeal is 30 days delay, they can condone. But when I filed the delay condonation application, he's sitting, keeping aside. He's not considering my delay condonation.
Then under Sestar, why they can take this matter up also?
Yeah,
They can
my lord, another aspect, my lord. Kindly see the order, impugned order is on 23/3/23, my lord.
Page?
The last page, my lord, 266.
Yes.
The order in appeal by the commissioner appeal is of 23/3/23, my lord.
Yes.
They filed
So the order, the instant case expired on 13/6/22 because the order was passed on 13/4/22. The order allowing the refund.
My lord.
13/4/22, correct?
My lord.
And then when was the refund done?
Refund was made on,
Received on?
after this 30 April, that amount has been refunded. 1 crore 70.
Date is
After
not-
passing the order,
That is
I
not
got
mentioned
that.
in the petition also, my lord.
You didn't mention that in the petition.
I have filed, I have mentioned.
No, when was it refunded?
Now, substantially, I am on the issue, my lord. Even the order which is under challenge before your lordship now, the appellate order, my lord, that is also March 23, my lord. They filed the writ petition in the month of
When is this order dated? It's 256.
23/3/23, my last 266, lordship will say.
Oh,
Now, the present writ petition is filed on
23/3.
28/2/25, my lord. Here is also a delay of 2 years, my lord.
Sorry. You're trying to beat limitation by coming a repetition.
No, my lord, it's a illegality. Actually,
Illegality where?
yes, section
The
30,
one for appeal?
they have, actually that is there, but here,
That is there, but you can't just.
my lord, actually it's not possible for the SSC to approach the state.
Why?
And then there is an illegality, so I, before your lordship, say there is a violation of section
You can't
35.
simplify it to that extent. Sorry.
They have
not so
violated
simple.
section 35 as
See,
well as
one thing
section
is that this
11.
order 13/4/22, you refunded immediately after that. Then even appeal order was passed 23.
No, my lord,
23.
Yes, my lord.
Then whereby that 9-day condemnation,
Yes.
you say 9 really has been not considered. Your
yes,
condemnation has not
my
been
lord,
considered.
page number 256 you can see. Page number 256.
You won't go to 256, you just take to 258. Which will
Yes,
get the order.
I have filed the delay condonation that is accepted in the office of the
So what
commissioner.
can this court do now? You had recourse to appeal, why didn't you go for appeal?
And Lord, actually there is a illegality. Actually it's a,
What he wants is what
My lord.
Mr. Sahu is trying to
My lord, here
advocate is that since he is
payment of
obviously
interest
delayed
is
9 days before the commissioner, then again now to prefer an appeal, so hopelessly delayed. How was it?
2 years delayed this
2
time,
years
this side,
delayed
my
this
lord.
time?
My lord, actually factory is closed. This is not running.
So how can we help it?
no one is there. So delay was 9 days. When I approached the commissioner appeal, he had passed the order, but he rejected my appeal on the ground of
You bring
limitation.
authority, we'll give you one chance, bring authority and negotiate.
My lord,
But in fact,
my lord,
I
actually there is
have
a
a
illegality.
authority.
My lord, here there is a illegality.
It's not a
section
question
35.
of whether interest is payable or you're entitled
Yes,
to it.
it
It
is-
is not no. That in your case it's totally on procedure first. Until you can beat this your own latches, then
No, my lord,
the question
actually,
of whether you're entitled to interest
Payment
is a
of
later
interest
stage.
is statutory payment. It's not going. There is no equity or all. This is statutory section 35. Section 35. Whenever 35F.
2012-11. 2012-11 SCC. Book SCC. 12-11-651.
Yes.
Only one para I'll read, my lord, para 15.
Para 15.
Yes, my lord. In our opinion, the SSC ought not to have filed a writ petition before the High Court, questioning the correctness or otherwise of the orders passed by the tribunal. The excise law is a complete code in order to seek redress in excise matters, and it may not be appropriate for the writ court to entertain a writ petition on Article 226 of the Constitution. Therefore, the
Because
land.
how is at that stage only? Forget about your statutory right to interest. You have already acquiesced that right, waived it by not proceeding in correct manner. Should we dispose it or we'll give you one more chance?
My lord, at this stage,
At this
Or
stage,
I may be
there's
allowed
no
to-
stage. The stage is over.
I may be allowed to go to the tribunal so that I will the limitation period that will be condoned by the tribunal. I mean direction. that I
Can
will
we
go there.
give that direction
Yes.
over and above what's provided by statute?
It's more than 2 years delay now.
So actually, I am before you. Actually, there is illegality there. So I
Forget
came
about
before
the
lordship.
illegality.
And this is the instruction of the department. The department cannot go beyond the direction of the instruction of the department. This is the departmental. When there is a section 35 compliance, the interest is to be payable.
Interest is payable. We have not come to that stage at all.
Yes.
It's not a question that we are adjudicating on whether you're entitled to interest or not. That's for them to adjudicate. Correct. And if they're entitled as per law, you're entitled. But then the very fact that your first appearance was barred by time, and now you've come after 3 years. 2 years, sorry.
Actually, Commission appeal would have passed the order on merit, but he did not pass the order on merit. So,
Right, and Mr. D. Sahu, on Praise, you will have to withdraw the application, availability to take recourse to alter remedy if available.
so the system may be condone the delay of this type.
In accordance with the law.
The tribunal shall take up the application and dispose of the same in accordance with law. Yes. Or if the writ petitioner approaches the tribunal, the same shall be disposed of, shall become disposed of according with law. That's all we're giving.
Any mention?
My lord, I may be allowed to move this matter, my lord, today, my lord. I may be allowed to move this motion, my lord, today as an unlisted matter, my lord.
What's the urgency?
My lord, in fact, there is no urgency. I have personal difficulty. Tomorrow I am leaving to Delhi, my lord.
Sorry.
My lord,
We'll come next week.
next week. Okay, and in that case, my lord, can it be, my lord? It will come up tomorrow automatically, my lord.
It won't come tomorrow. It depends on the registry. Sorry, yes. We are quite tied up now.
It's already numbered, my lord.
Then it'll come tomorrow. Tomorrow, then, yes. Yes. What's the matter about?
Well, it's relating to pension matter, my lord. My problem
tomorrow,
is,
then.
my lord, my problem is I am going to Delhi for my wife's operation, my lord.
So it'll come tomorrow because we're a bit tied up today. Because the court's not sitting after 1:15. Yes. Yes.
May I please, Your Lordship?
Yes.
I beg to mention item number 20, Your Lordship.
Number?
20. Mr. A.H. Hazarika is not
Mr.?
keeping well. A.H. Hazarika, Lordship.
Yes.
Lordship is regarding the demarcation.
Yes, Your
We'll
Lordship.
dispose of today.
No, Your Lordship, because
No.
he is not in a position to argue, Your Lordship, because
There's nothing to argue.
he is coughing,
They
Your
have
Lordship.
failed to recognize their own land, Your
Yes.
Lordship.
Last chance, Your Lordship.
Last chance for tomorrow.
No, Your Lordship.
See, before the year ends, will all these deadwood cases will dispose them off. So you can start a fresh start next year. Okay. Right?
Yes.
Listen next week then. Yes.
Obliged, Your Lordship.
A request is listen next week. Yes.
Lordship, I beg to mention item number 22.
20?
22.
Yes.
Lordship, we are unable to take up the matter due to personal difficulty. If this matter may come up after vacation.
No objection, Your Lordship.
What's the matter about?
Lordship, managing
Regularization into service. Regularization into service. The petitioner is a teacher, Your Lordship.
Still in service?
Lordship.
Still in service or
Still in service, Your
still
Lordship.
in service? Okay, after vacation, at the request of Mr. So-and-so for government advocate.
Lordship, I beg to make a mention of item number 23, Your Lordship.
Yes. Yes, and it's connected to
Item 24, Your Lordship.
and who's appearing? You have the objection?
For the private respondent, Your Lordship. Performer
Yeah, objection.
respondent. No, Your Lordship.
When tomorrow?
After vacations, Your Lordship.
What's the matter about?
Is regarding
School
the
managing
school
committee,
managing
Your
committee. They're supposed to file an objection regarding the inquiry report, Your Lordship.
In the miss case, Your Lordship.
Item 24.
Lordship.
What miscase you filed? Where's Mr. Thapa? He's not around.
No, Your Lordship.
All the matters in the miscase. Yes, see the last order, we can't adjourn this matter any further. Even since April, we said we'll met here for disposal with Mr. Ali.
Lordship. Last
What to
chance,
do?
Your Lordship.
Last chance.
Lordship.
Who's appearing in item 24? Who's appearing?
I'm only for 23, Your Lordship.
Who's appearing in item 24? Is the interim order operating?
Lordship,
Has been vacated.
Lordship, in item number 23, the state has filed an inquiry report and they are supposed to file an objection.
No. Are there any interim orders operating right now?
No, Lordship.
No, that's fine. Yes, so. Just after vacation, please.
Highly obliged, Lordship.
Obliged, Lordship. Not obliged, Lordship.
Yes.
May I please, Lordship? Lordship, we beg to make a joint prayer of item 21.
Yes, Dr. Mojika is there also.
No, my
No, Your Lordship. They,
Oh no, Mr. Mazumdar speaks for all the respondents.
Yes, Your Honor.
Do one thing. 21 prayers, joint prayers been made on behalf of the parties for adjournment to when
after
next week.
vacation, Lordship.
notifications of Mr. M.K. Mazumdar on the last occasion submitted that he will be representing all the respondents, correct? Accordingly, the same should indicate in the first title. Yes.
Obliged.
Yes, yes.
Lordship, I beg to mention item number 18 on behalf of H. Carvano. Is in discourse.
No objection.
No objection, Your Lordship.
When? Next week? When do you want it? What's the matter about?
Cessation of service.
Okay, after vacation, no urgency. Yes.
Lordship.
Yes.
Your Lordship, I beg to mention item number 25 to 28. These all are connected matter, Your Lordship.
Mr. Nath's matters?
Mr. B.O. matter, Your Lordship.
25 to 28?
Yes, Your Lordship.
What's the matter about?
It's more matter about the challenging the order, revocation order.
What's the matter about?
The regularization was revoked, Lordship, as the authority which has issued the regularization was, he doesn't have the authority.
Incompetent.
Incompetent.
Why Mr. Yuban doesn't do the matter?
Learned Council is out of jurisdiction, Your Lordship.
Out of jurisdiction is a good prayer. Well, then after vacations?
Yes, Lordship.
Yes, okay. It's 25 to?
25, 28.
Yes. Yes.
Deeply obliged, yours.
Supplementary list item number 1.
This matter has been pending for a long time. It slipped. Anyway, but after examination, I think you should go for division bench for that matter. Which there's a special bench to take up tribal matters. We listed on Thursday before the concerned DB. That is the bench taking up tribal issues. It's better also since it's a question of custom also.
Obligement.
On list on Thursday. Visit for listing on the next available date.
Item number 2.
Second copy di dalam kan? Petition second copy kan? Yang second copy berapa second judge.
May I please, my lord?
Yes, Mr. Kira.
My lord. My lord, I have served in the Assam Rifle for 22 years, and
what happened now?
My lord, since I have retired, now I have assumed the character and membership of being an ex-serviceman of Assam Rifle, my lord.
You are the
ex-serviceman, my lord. Since
okay, ex-serviceman.
I'm an ex-serviceman.
You retired.
Retired, my lord.
Yes.
My lord, while I was in service, there were compulsory deductions which were being made from my salary, my lord, and which at present is akin to Rule 202 of the Assam Rifle rules. But back then, when the Army Act was applicable, it was under Rule 205 of the Army Act, Army rules, my lord.
What deductions does he? What does this matter? In action upon union as per law against misuse of name Assam Rifle.
My lord, I'm coming to it.
Then,
so my lord, what has happened is there was an organization of the Assam Rifles, that is Assam Rifle Ex-Servicemen Association, my lord.
Registered.
ARESA, yes, my lord. And this is not just a registered institute body, my lord. The compulsory deductions which were being made during service, all servicemen have to give compulsory deductions from their salary, which goes into the coffers of ARESA. Now, my lord,
ARESA is the welfare.
It's the welfare.
What's the full?
Assam Rifle Ex-Servicemen Association, my lord.
Assam Rifles
Ex-Servicemen Association.
ARESA.
ARESA. My lord, Annexure 1.
No, Arewa, ARESA.
Arewa is, my lord, that is the whole grievance I have. Now
you are, 1 second. But you are Bajinder Singh.
I am Bajinder Singh. I'm an ex-serviceman.
And then the association has not come. You're not on behalf of the association before this court?
No, my lord. Because I am a member of this association. I have made contributions to this association when I was serving. And this association is there for my welfare. So, my lord, I am directly affected because I have made those payments and deductions also, like others. Now, my lord, certain individuals have floated an organization by the name of Arewa. They are using the logo of Assam Rifle, they are using the name of Assam Rifle, and it is registered.
Registered where? In Shillong?
In Kerala, my lord.
Your association is where? In Shillong?
Shillong, my lord.
You are ARESA.
My association is not just registered, my lord. Annexure 1, page 24 is the SOP of Assam Rifle. It has received the sanction of the competent authority. That is why deductions can be made. So I have written 3 representations to Assam Rifle, my lord, at Annexure 5, page 64 to 66.
Now, one second, Mr. Akira. Now, the thing is that this Areva is recognized by them.
No, my lord.
It's not recognized.
And they are not.
What is their function?
My lord, they are only collecting money in the name of Assam Rifle. We ex-servicemen are now confused. The reason is ARESA is there for not just my benefit, my lord, but if I die, for my kins, my relatives.
No, fine. Now, what are they trying to use Areva?
My lord, we have written applications to them asking if you have given NOC to Areva, because without giving an NOC, it cannot be registered, my lord. The Emblem Act will be there. Because they are using the emblem of Assam Rifle.
You mean it's an illegal organization?
My lord, I am
taking money from these ex-servicemen.
My lord.
Then are you? Then what is the? You have to become member of this Areva.
I am not a member of Areva. I am a member of ARESA. By virtue, everybody who has served in Assam Rifle has
to be member of.
Has to be, because he has given compulsory money. He has given
while in service.
While in service, my lord. And that money has gone into the coffers only for my betterment and my family's.
Coffers, whose coffers is gone?
Of Areva, ARESA, my lord.
That is what. So now you're saying this Areva has come. Is it dipping into the money contributed by the Jawan?
No, my lord. It is misguiding us. It is showing us that it is an organization of Assam Rifle, because it is writing Assam Rifle.
That's confusing. Yes.
But the main grievance, my lord, there is one official entity called ARESA, my lord.
Yes.
That is governed by the Assam Rifle rules, my lord.
Yeah.
Compulsory deductions are made for the benefit of post-retirement benefit, my lord. Or even for war casualties, battle casualties, and other things, my lord. Now, so something is what has happened, my lord. Another private individual has formed another, that's called Areva, and is registered in Kerala, my lord. Now, his grievance is that he, being a ex-serviceman, he is confused which one is the official one and which one is unofficial one.
So why hasn't ARESA come forward then?
ARESA has not come forward. He has come forward.
My lord, I have written applications.
No. You're fine. On your own, you've done what you've done. But why ARESA is not aggrieved with the floating this new ex-servicemen welfare association?
My lord, it is.
Is there any conflict of interest among them, or are they working in their own jurisdiction, maybe for Kerala or something, or servicemen serving in Kerala who maybe want?
No, my lord. It is all India, my lord.
My lord, it is in all India. They are using Assam Rifles almost look-alike insignia and logo.
Do they have any no objection from the Assam Rifles to start this?
My lord, that is what I have written the letters to them. That have you given them any no objection certificate?
Where's that Areva? Let's see in the lecture.
My lord,
where
page
they published something.
Page 57. My lord,
what have they published? Let's see. It's 59.
Page 57 onwards, my lord.
Yes. You obtained the constitution.
My lord, I don't have that. I could not obtain it, but this is what they are using, the insignias and the logos, page 57, 58, 59. My lord, at page 62, they are asking money.
We're asking for money.
My lord. Page 62 is the translated copy, my lord.
Office, Assam Rifle External Welfare in all India. 2014.
My lord.
This ARESA. No, it's Areva.
Areva. This is Areva.
So the registers now over 11 years they've been registered.
My lord, their activities have come overground very recently, and my lord, if we can visit Annexure 1.
Now, 1 second, let's see your 62 where they're asking for money.
My lord. My lord, Annexure 3, page 62, my lord, is the translated copy.
Read it, yeah.
My lord. All the Assam Rifles VP Sahabs, Mem Sahab, my warm regards and a short message for some information. Our Assam Rifles annual general meeting is being held in Chitwan on 2nd of November 2025, and it is a humble request to all that all the Sahabs and Mem Sahabs must go to this meeting. But before going, one small thing, that all the arrangements for the food and lodging of the guests coming from India will have to be made by us, the Nepalese Assam Rifle Ex-Servicemen Welfare Association. As per the post, rupees rank wise.
Oh, this is Nepal.
My lord, I extend to Nepal also. This is
No, this is Nepal, yes.
No, my lord,
this is everybody. They said even.
This is one of the.
Where does it say it's organized by Areva? Does not say. This is Nepalese Assam Rifles Ex-Servicemen Welfare Association. Then the next one.
My lord, this is Areva. AREWA. This is Assam Rifles Ex-Servicemen Welfare Association. The acronym is Areva. It is their Nepal chapter. Likewise, they are doing it all over India. And
This
my lord,
will be connected. Will come Subedar as our case pending for decision before Delhi High Court. What case pending for decision?
my lord,
It will be challenged there.
this is the case of dual command. Assam Rifle, it has been decided as per my knowledge, I think yesterday or day before. The dual command case has got nothing to do with us here, my lord, because dual command is that Assam Rifle is under.
And what is this annexure for?
My lord.
You read it. What is this?
My lord, annexure 4, my lord, is a video of YouTube. What they are doing, they are also publishing maps of the deployment of troops, not just Assam Rifle, but also.
No, what does this say? This one transcript.
My lord,
read it.
Hello to all members. Our place in the Assam Rifle should be within the army. There is no doubt that it's a paramilitary force. The DGR repeatedly tells us to put in the CAP and CAPFs. It is deeply wrong. There is something fishy about it. Look, army officers misuse the Assam Rifles manpower, their soldiers and vehicles. They use it for their wives and children. They engage numerous people in their picnics and Sir Clubs. Sir Club, Officers Club, my lord. This is illegal. During training, we swear in oath that we are ready to die for our country. That government duty, public money is used to make.
No, what to do with it, Arewa?
No, this has got nothing.
What is this?
My lord, this is to show that they are also publishing maps, my lord. In these videos, when they make, they are asking their soldiers to make videos and send. In that, sometimes our deployment maps are being published.
No, he's talking about picnics and see, this is the only thing that misuse of the force. There's nothing to. Where does it show that is done by Arewa? That
My lord, if my lord can see annexure 1 at page 24.
Okay, uploading a mutinous and inciting content.
My
The
lord,
only person who's active, it appears, to challenge this Arewa. Yes, you get instructions, Mozika. Otherwise, what even as locals now, whether have you made Arisa a party?
No, my lord.
Why?
My lord, because
they should be pro forma party.
My lord,
you include them as party.
Assam Rifles is a party.
What?
No, Assam Rifles. Arisa should be a party. Also, President Secretary pro forma, whether they support his case or not.
Yes.
My lord, my grievance is that I have.
Your grievance is fine,
have
but
they
then,
given an NOC or
might not
not?
be a necessary party. Is a proper party. This one. Yes. We'll include it by the order of the court in pleading them. Yes, heard Ms. N. Kera and counsel for the petitioner. Dr. N. Mazika, Senate DSGI with so-and-so is present. On behalf of respondent 1 and 2. Notices to go to remain respondents within 3 days. Stop. The grievance as projected by the writ petitioner is that he is a member of the Assam Rifles Welfare Association.
Ex-serviceman.
Assam Rifle Ex-Serviceman Association, which is recognized by Assam Rifles and is the official ex-servicemen association. Stop. However, they submitted a new organization known as Assam Rifles Ex-Servicemen Welfare Association.
All India.
All India.
All India, for short, Arewa, has been in operation in the state of Kerala. Stop. And Kerala, and has created confusion with regard among the ex-servicemen. Stop. And has also been soliciting donations.
My lord.
For their for its function stuff. Dr. N. Mozika is instructed to is directed to obtain instructions with regard as to whether this Arewa has received any NOC or is a legitimate organization. Next paragraph, it is noted that the association, that is Assam Rifles Ex-Service Association (ARESA), to which the petitioner belongs, have not been arrayed as a party, and the petitioner is before this court individually. For proper adjudication of the matter, this court directs that the Assam Rifles Ex-Service Association (ARESA), through its president or secretary, be arrayed as pro forma respondent number. Pro forma respondent number 6 in the area party. Registry to make the necessary correction a petition to take steps also for serve notice on the newly impeached respondent number 6. Just after 2 weeks.
Yes.
My lord, it has to go to Kerala also, 4 and 5.
This after 2 weeks, it's it might come back. You take steps immediately, yes.
My lord. 4 and 5 also noticed.
Yes, 4 and 5. Yes, we already said that earlier.
Item number 3.
Obliged, my lord.
Yeah, what is this?
Well, here the petitioner is the senior most judicial magistrate in the district council, my lord.
Senior most?
Senior most, my lord. Well, in fact, the cadre strength as it appears, my lord, is 1 judge, 2 additional judges, my lord, and 7 magistrates.
1 judge,
2 additional judges,
and 6 and
7 magistrates, my lord.
Current strength.
Current strength. That appears to be sanctioned strength, my lord.
Is that correct, Mr. Ringo?
Yes.
7, just
1, 2, 7.
7 judicial magistrate first class, 1 judge, and 2 additional.
2 additional judges.
2 additional.
Yes, my lord.
Okay.
Now, at present, my lord, judges post is filled up. 1 additional judge is serving, my lord, and 6 magistrates are functioning. 1 post of additional judge is vacant, and 1 post of judicial magistrate is vacant right now. Now, my lord, all these years, for the data, like what we could gather, the additional judge post is always filled up by promotion, my lord, of magistrates. And similarly, my lord, judges post has also been always filled up by promotion of additional judges, my lord. Now, here what happened, my lord, to the vacancy that is lying right now, my lord, the district council is advertised by direct recruitment, my lord.
Yes.
Now, our case is, my lord, that is
he is not eligible as yet.
Well, there is no eligibility.
When is he appointed?
My lord, the petitioner was appointed in 21 July, my lord.
Now going 25, so he's got 4 years of experience.
There is no eligibility, my lord, anywhere. I checked up all the rules, my lord. Number 1, my lord, there are no service rules in the district council, my lord. So
but there must be some executive instructions operating
now,
with regard to eligibility.
So that's one aspect, my lord. And even the eligibility is a criteria, my lord. If I assume that it is 5 years, my lord, though I have not completed 5 years, but I will be completing 5 years in 6 months' time, my lord. But at this stage, bring someone appointed by direct recruitment, my lord. So, my lord, what I am praying, my lord, first they should clarify by service rules, my lord, that which posts are for direct recruitment and which posts are for promotion, my lord. In the absence of that, my lord, we had a legitimate expectation, my lord, as the senior most judicial magistrate, that in due course of time, when I acquire eligibility, or if they set up any eligibility, my lord, I'll get promotion. Now they try to interject that with a direct recruitment, my lord.
But then, if you're not qualified, you don't have 7 years or 5 years. But that's the general qualification necessary for district judges post, and they're equivalent to district session judge, additional judge, and judge. Correct?
Yes, my lord.
Yeah. So that is the only consideration this court has to see for proper administrative justice.
Or at least they should clarify that this is
whether a person is, when in the absence of a person who is not yet qualified to be promoted, whether they can resort to lateral entry by direct recruit. Because it's been done in some cases also, suppose in the level of grade 2 officers, suppose in this normal judiciary, where they have just magistrates and they have grade 2, then grade 1. Correct? So in the absence of, these judicial magistrates who are eligible for promotion to grade 2, lateral entry direct, it has been advertised. And even in our judiciary, 1 or 2 officers are there who have entered direct to grade 2 directly.
So, my lord,
that's
what I am praying, let them come up with a clarification, my lord, that this is a one-time measure only, if at all, my lord. And why can't they wait for 6 months, my lord, when 3 of them they were appointed on the same date? I am the senior most, my lord, 2nd and 3rd were
now
also
appointed when 2nd and 3rd, they appointed same day.
Same date, my lord.
Or 21, so they're all eligible also.
They'll all become eligible, my lord.
To
truncate their all promotional avenues, my lord, at this stage, my lord. Where they'll go, my lord?
So have an examination among 3 of them.
They can have that,
in fact, all of them have applied
for example
for the posts.
To direct recruit.
To direct recruit
directly.
Now, the problem with the petitioner, my lord, is 34 years old. Now, one of the requirements is that the candidate should be 35
years old.
35 years old.
Now,
so what my friend is saying, wait till I become 35.
Wait till you celebrate your birthday and complete 6 months.
But where are the rules, my lord? There are no rules on what basis they are saying that 5 years experience is required or 35.
On what basis have you advised for direct recruitment?
My lord, my friend said there are no rules, but in fact, in his petition before the executive committee, he has cited. Your lordship will come to the last page, page 23.
Those are general rules, those are not for judicial officers.
Yes.
Reference may, my lord, para 3, reference may thereafter be drawn to chapter 3, rule 15, 20, and the provisions to rule 24 of the service rules of the council.
Page 23.
23, my lord, last page.
Yes.
Paragraph
Yes,
3.
yes.
Reference thereafter may be drawn to chapter 3, rule 15, 20, and the provisos to rule 24 of the service rules of the council, which mandate that recruitment to class 1 post shall be made by promotion based on merit, and that such promotion shall be from amongst the officers in the class immediately below. In light of these statutory requirements, my candidature falls squarely within the contemplated zone of consideration. Now, my lord will come to rule 23.
Where is that rule?
The petitioner has
quoted it. Has he quoted the petition?
No, but these rules are.
The petitioner has left out rule 23, which is the most important.
Well, these rules are, in my humble submission, cannot have any applicability to judicial officers. These are for administrative posts.
Awaiting the shelter of this rule, then when
now they're saying no.
In representation, that is a mistake. I told you.
That is a mistake.
But in representation, we have not pleaded, we have not taken shelter of this.
Yes.
Rule 23, my lord, chapter 3.
Kindly see the heading of the title of the.
Suspension of lien.
No, my lord, the first page, my lord. These are meant for.
Yes, anyway, we also operating in the area with the no rules and only governed by executive.
In fact, rules have been made, my lord, but
chapter 3, which page?
Page 28, my lord, according to my rule 23.
Yes. No, I think you're looking at different. What rules are you referring to?
I'm referring to the Khasi Hills Autonomous District Council Service Rules, 1961.
Yes. This is. One second.
Hello, we can help you.
1 second. Yeah, general rules. So promotion is service, right? 23.
Yes.
Okay. Yeah.
Direct recruitment may be made only to the post. It should be posts of grade of lower division assistants, stenographers, and typists. All other posts shall be filled by promotion from amongst the existing members of the class next below them.
Yeah.
Provided that recruitment to the post of class 1 service shall be made by promotion from amongst the existing members of the class next below them on the basis of seniority, merit, qualification, efficiency, and experience, or by direct recruitment as the committee may decide. Well, now the committee has decided that it should be by way of direct recruitment. That pointed out
these rules. My lord, kindly the rule was sub-rule 1 lower division is what relevance it has on?
It was very much. No, because they are questioning the authority of the executive committee, whether we can go by direct recruitment.
See, one thing, Dr. Modi, in the absence of rules gives them more flexibility.
Yes.
But my lord, they can. My lord, in fact, I'm not armed with that. There is a direction by this honourable court in earlier matter, my lord, to frame the rules, my lord.
That is true, my lord.
That was in.
Rules have been framed.
Quite some time back.
Rules have been framed, but they have not been assented by the governor. Those rules are there.
Some interpretation is required, my lord. The last date is 15th of December. They can file an affidavit before that, my lord. The matter may be. Either way, my lord.
One thing is also what is the contempt of what is. He is still 34 years old.
Yes.
He doesn't have 7 years. That is the the.
My lord, he has 7 years, my lord. After Supreme Court ruling, my lord, the practice will be counted, my lord. And service as judicial officer also.
So then he has to apply for direct recruitment.
Yes.
If he wants to post 7 years, he wants to take advantage of
take advantage of that.
Practice. That is different. But if the thing is that if you want to go by zone of consideration, you have to have at least 7 years of experience.
My lord, 7 rule, we are taking analogy from the regular judiciary, my lord. They don't have rules, my lord. Regular judiciary has rules.
So in the absence of rules, as your lordship has pointed out, we have.
My case basically, my lord, there are only 2 posts, my lord, for 7 judicial magistrates.
So you're saying that once filled up, you'll never be promoted forever.
You'll never be promoted, my lord. only the first incumbent, when he or she retires, my lord, then the window will open for us.
The present incumbent, my lord, had served for 14 years before she was promoted.
Yeah.
Yes.
That has to be kept into consideration
No,
also.
14 years, we are ready to wait for 14 years. It's not a
Yes,
question that I should be
they
given
served only
promotion
4
today.
years and
But our avenue should not be, cannot be closed just like that, my lord, by administrative action, my lord.
Anyway, I heard Dr. N. Mozika Leonard in a council with MS Mitcham, Mr. Titi Wingo is present with Mr. Stonso. As such, no further notice required on the one of the respondents. Stop. The grievance of the writ petitioner is that is with the attestment dated
page 21, 13th November.
Page 21. Attestment dated 28 July, no. Page
13th November. Page 21.
Yes, with the attestment dated 13/11/2025, advertising for recruitment, direct recruitment to the post of additional judge, district council court.
additional judge.
Additional judge, council court. Stop. It is submitted by the Leonard Senior Council that in all past circumstances, this post has been filled up by promotion, and the petitioner, being the senior most among the grade 3 officers, is therefore within the zone of consideration for promotion to the said post, notwithstanding his notwithstanding any other consideration. Stop. He therefore stop. Mr. T. Lawless, please, he allowed some time to obtain instruction to file short affidavit on the authority of the district council to issue the impugn advertisement. Published after 1 week.
And
come on the 10th.
Also, what are the promotional avenues or the otherwise for grade 3?
Why we go into all this?
Yes.
Court will not.
That is the. This is a service matter.
Give them CPS, ACPS. So that's what's done in other places. People are entitled to 1 or 2 promotions. Yes.
Let come on the 10th.
December. 10th. Otherwise, you have to give them that. Some people is served for their life, no promotion. So after 10 years.
No, my lord, if that was the case, my lord, here is a case that the post is there, my lord.
No, but the thing is that, see, the only consideration that he's not in 35. He's not complete 7 years. That's the thing.
Item number 4.
So they should say that it is one time, my lord. They should say that in the rules.
You have given them the hint, so let us see. Yes. Yes, Mr. Sama.
Please, Lordship. Lordship, this is a second round of litigation. But this is for creation of new village as per the Castilian Autonomous Council
litigation where
1971. Lordship, this earlier order, Lordship, where that page is the annexure 1. Lordship, page 19.
No.
One.
Order is that 88, my lord. The earlier order.
Is that notification? What is this? What do you want to show?
Yes,
the first round litigation, where's that?
Yes, notification that is that.
No, first round litigation.
First round of litigation, yes, page 88, my lord. First 88, para 3 relevant.
Yeah.
Lordship. Annexure 20, page 88.
Yes.
As per this order, your lordship, we have approached the district council by way of representation, and that was disposed of. Then directing the private respondent to issue the no objection certificate. That relevant part is there, lordship. That we have our representation was on page 21. No, not 91. Annexure 21, lordship. This is our representation, and then next, my lord, this page 99, whereby the Joint Secretary to the Executive Committee
has rejected.
Autonomous District Council have written a letter to the private respondent number 4.
Have you been recognized now?
Not recognized, because the private respondent number 4 have not response to even to the letter issued by the Joint Secretary to the Executive Committee.
Who's number 4?
This aim of let the direction be issued again.
Aim to same of whom?
Same of Maharam.
Let him appear first. Okay.
Let a notice be.
Mr. P.T. Sangma, let council issue notice. The student or senior council, which council is present on behalf of 123. No further notice required. That notice issue is on number 4 within 3 days.
Lordship.
Yes, up to 2 weeks. Yes.
Lordship. House minutes watching.
Daily list item number 1.
It's been served. So, they appeared. Who's appearing on behalf of?
Respondent number 9.
Number 10. Yeah.
Who's appearing for CM Mohsen Ram? You appearing? 6, who was 6, 7, 8?
The Shnong, Your Lordship.
And what about this
9. Respondent number 9, the newly pleaded.
You appearing?
No, my lord. And the
This
petition.
for the petition.
Then? Oh, sorry.
No one, man.
But already
Whether
been
the
served.
service report has.
No, it already come.
It's already come.
Yes, a status report from the senior superintendent of post offices, Meghalaya, shows that notice that the newly implemented respondent number 9 was served on 310. Newly implemented respondent number 9, that is Hima Mohsen Ram, was served on 3/10/2025 by Muslim Support Office. However, there is no appearance on his behalf today. This court notes that the appearance necessary in view of directions of the division bench to complete the process. So, what to do?
Next week, my lord, you can fix.
No, not next week. Fix. I mean, how do we have to?
I
He has to appear first.
Yeah.
Then.
Due to this his allegation, I am not able to go back in my own village.
Accordingly, this is where's the police station in Mohsen? This is a police station or is it a
police station?
Outpost.
Police station, Your Lordship.
Accordingly, the OC of Mohsen Ram police station is directed to inform the respondent number 9 about
10,
the pendency of this case, along with a copy of this order. Part of registry, which is to be which will be furnished by the registry for appearance on the appearance of engagement of counsel before the next date. This is matter. We have this is out of vacation then. This matter of vacation. On the other part, also what's happened?
My lord, a somewhat connected submission, my lord. There's an earlier order from this honorable bench on 14th of August directing for establishment of a police picket at the spot, my lord. Police picket was set up, my lord, but we've noticed over the past month or so,
they've not been there.
The presence has disappeared, my lord. If Lordship would kindly direct.
Yes, it is also informed to the court that though a police picket was posted at the site, that is at the site, yes, it is. Come on. The police what? Picket have been posted at the site. So the same there's no presence presently. So it's expected that as per order of the court, police the security should be restored in the area. Yes.
I not see number. Let's respond number 10. Yeah,
number 10. Okay, change number 10. Thank you.
Thank you.
Item number 2.
Please, Your Lordship. Lordship, may kindly peruse order dated 12/11/2025 of this honorable court.
Yes. Yes.
Lordship, we have gone through the order dated 31/10/2025 passed by the Appellate Tribunal for Electricity.
Yes.
Now, after going through, Lordship, we may be allowed to withdraw this writ petition with a liberty to approach the Appellate Tribunal for Electricity and agitate all the points that has been agitated in this writ petition. And
Fair enough. Yes. Yes. Yes.
Yes, my lord. The issue is that they want to withdraw. I have no objection to withdrawal, my lord, with liberty, because and if liberty has to be in accordance with law only, my lord. That is what I pray for. They want to withdraw. I have no objection, but withdrawal in accordance with law, because they have agitated some of the issues here. Though, and we have said that there is an alternative efficacious remedy. Our objection was to that extent, my lord. But if they want to withdraw, I have no objection. But they want the affirmative order from your lordship that they can take up the matter before CRC, my lord, or before MECRC, my lord. So they want to withdraw simplicity. I have no objection. With liberty, I have also no objection.
Well, only for them to approach alternate remedy to
Yes,
remedy, yes, before the concerned tribunal or commission, and that my matter will be dealt with in accordance with law. And naturally, if further they are permitted to raise whatever issues they want to raise.
Yes, my lord.
You have Mr. What was his name? What's you have Mr. Pritam Barua? Yes? Muted. You are muted, yes.
Muted.
I'm not muted.
Yes, okay, yes. You have Pritam Barua.
Yes, Lordship.
Yes.
Lordship, I have one more prayer.
Yes. Yes, yes.
Lordship, am I audible?
Yes, yes. Yes. What do you want to say?
Lordship, I want to say, I don't know, I have been muted by the site, I believe.
No, not muted by the site.
Lordship, I have one more prayer.
Yes.
Delay in filing the appeal, Lordship, that may not be a ground for dismissal of the appeal.
My lord, that he has to take up before the appropriate commission, my lord.
Yes, okay, take down, Mr. Pritam Barua, take down, yes. Mr. Pritam Barua, learned counsel for the petitioner, submits that the order dated 31/10/2025 passed by the appellate tribunal for the city in similar matters has been studied, and he prays that he may therefore be allowed to withdraw the incident application with liberty to approach the appellate tribunal, and also placing all the concerned facts for proper adjudication. He further prays that the time spent, it mentioned that with regard to delay, that due consideration be given by the appellate tribunal in this regard. Stop. Next, Madam Mr. Your opinion, Advocate General or as
Advocate General, my lord, there is
yes,
no
yes. Then Advocate General has no objections and submits, but however submits that everything, the process to and submits that the what is something that it should be in accordance with law, whatever requires the liberty granted, if liberty be granted to the writ petitioner to withdraw, whatever recourse thereafter should be in accordance and as per law. And who's the other one? Yes, so and so is present on behalf of this point number 3.
Respondent number 2.
Yes, my lord. Respondent.
On hearing the
Respondent number 2, my lord. Respondent
number 2. Sorry. Okay. On the submissions of the council parties, accordingly, this application is closed on withdrawal. However, with liberty allowed, granted to the writ petitioner to approach appellate tribunal to raise all the related issues. That's all, and the tribunal on the application or appeal being preferred shall give due consideration on the question of condemnation and decide in accordance with law. Matter stands closed and disposed of. Yes.
Grateful.
Item number 3.
Lordship, for the respondent, they have filed the affidavit. I pray for filing the rejoinder, my lord.
Yes, Mr. Peterson prays was allowed
3 weeks.
4 times of file rejoinder. Yes, this thereafter.
Lordship. Lordship.
Yes.
Your Lordship. My Lord, I beg to pray for 2 weeks' time to file my rejoinder.
You already paid earlier on.
This is the third time. And the final.
Third time?
Third and final.
Yes, for the 2 weeks' time. Final opportunity of 2 weeks is allowed for rejoinder, list thereafter.
5.
This matter has come back from the mediation because there was no settlement.
Your Lordship, we need some more time. Lordship. We need some more time, Lordship.
May praise for the 2 weeks' time for rejoinder, list thereafter.
I do pledge.
6.
Item 6, I am appearing for the respondent 5 to 7, my lords.
1 to, oh yes.
My Lord, this is the 8th time, my Lord. They have not filed the affidavit.
No, my lords, we have been recently engaged, my lords.
Who are you?
And my lords, 5 to 7, my lords.
MECL.
For MECL.
MECL.
Why? What's the matter about?
This is, they have acquired a land for a Hydel project, my Lord. This is the second round of litigation, 2017.
When can you file your?
My lords, a matter has some consequences for the corporation, my lords. May keep it after vacations, my lords. We will have
But you file your affidavit, yes. Though submitted by the petitioner, that's the 8th time the time has been sought in interest of justice. The respondents 5 to 7 are allowed further time. It's expected that upon the next date, the affidavit should be on board.
1 to 4 also they have not filed affidavit, my Lord. I don't know whether they are filing or not.
The order applied to MSS Lalu on behalf of 1 to 4 says that no affidavit forthcoming from these respondents on this after vacations expected on next date. The affidavit should be on board. Please.
7.
Much obliged. Much obliged.
Yes.
Please, Lordship, I am seeking some more time to file my rejoinder, your Lordship.
Yes. 2 weeks' time is please allowed for a time for joining. Yes. Yes. Yes.
Time for file rejoinder, Lordship.
Who's the petitioner? Who's for a respondent?
I am for the
Who's for a respondent?
May I please, your Lordship? Lordship, I am appearing on behalf of Dr. P. Agarwal for respondent number 3.
What about number 1, 2? Indian Coal India. You have 3. You are appearing for number 3 and 4.
3 and 4. They have already filed their affidavit, Lordship. So
yes, okay.
They allow some more time to file.
Yes, Mr. Priyambura pays funds allowed for the 2 weeks' time to file rejoinder the affidavit filed by respondents 3 and 4. Yes, list accordingly and so on. Yes.
Lordship, interim order passed earlier.
Interim order shall continue next date. Yes.
9.
Maybe Your Lordship, we have filed our rejoinder yesterday.
We posted for hearing after vacation.
Parties submitted pleadings are complete. This is the matter for hearing after vacation.
10.
May please, your Lordship. Lordship will file our affidavit within 1 day's time, my Lord. Lordship, myself also, Lordship. Within this week, I'll file. My affidavit is ready, Lordship.
Yes, MS NG Shulal Senior GA for 1 to 5 and MSP Barachai for 6. Submit that have to be filed within
this week, Lordship.
Within this week itself. Yes. Lists after vacations for rejoinder again.
Much obliged, Lordship.
11.
My Lords, I seek some more time to file my rejoinder, my Lord.
Your Lordship, we have filed our affidavit in opposition, Your Lordship.
How many times is seeking?
This is the third time, my Lord. My Lord, just one request, my Lord, if it can come after vacation because the petitioner is out of station, my Lord.
3 weeks is granted. After 3 weeks, I think we cover vacation.
Highly
Much obliged, Your Lordship.
12.
May it please, Lordship.
We filed our affidavit, Your Lordship, on the last date.
I'm praying for some time to file a rejoinder, Lordship.
Mr. Praise funds are out. 3 weeks time for the rejoinder. Much thereafter.
13.
Your Lordship, I've received the copy of the rejoinder filed by the petitioner.
I filed today. By whom?
Filed by the petitioner. This morning I received it.
Case now? Yes.
Yes, I filed today, Lordship.
This morning.
Can you pose the matter now?
Not today, Your Lordship. After the vacation, perhaps.
Is the school not having managing committee now?
For the last 2 years, my lord, no managing committee on account of these litigations, my lord. I'm yet to receive a copy of that rejoinder. I'll receive a copy. Matter may come up next. We can dispose, my lord.
Lordship, the case is that Lordship has taken a very serious note on the last occasion on the conduct of the directors. He passed one order.
See, your rejoinder has been filed today.
Yes, I filed.
You should have filed it beforehand.
My
You filed today only.
So I'll receive a copy. We'll respond, my lord. Let it come next week.
You filed today only.
Yes, this
today
morning only I
The
received a
rejoinder has
copy.
just been filed today itself by the writ petition list after 1 week for further orders. Yes.
For hearing, Lordship.
For further orders, we not see for
Lord.
hearing list.
14.
In number 14, Your Lordship, I'm appearing on behalf of the state, Your Lordship. We want some more time to file our affidavit.
What's the matter about?
This is regarding the work charged employee, Your Lordship.
Yes, 2 weeks further time allowed for affidavit. Yes.
Oblige, Your Lordship.
15.
Please,
Yes,
Lordship.
Mr.
Lordship, we are still awaiting the service report for
Why,
private
no, this-
respondent number
this-
5 and 6. We have taken
4 and 6.
Yes, 4 and 6, Lordship, yes. 4 and 6.
Will require some time.
April 4 and 6.
For number 6, respondent number 6, Your Lordship.
What number 4?
Number 4 is principal college of Tura.
4 will appear.
4 is principal of Rongkon.
My lord will appear for the 4 also, my lord.
Mr. N. Singkon today submits that he will be appearing for respondent number 4 also.
1 to 6,
For 4
1 to
also,
5.
That means for 4 also. So notice is complete on response 1 to 5. Stop. MSEDCM
Respondent number 6.
has entered appearance today in behalf of respondent number 6. Such service complete on all respondents. How much time will require affidavit?
My lord, 2 weeks time, my lord.
The response brief one allowed. 3 weeks time for respective
Lordship.
affidavits. This thereafter.
Most blessed, Lordship.
16.
Please, Your Lordship.
Five
I'm praying
months.
for 5 months.
5 months. Yes.
Much better.
Hearing 17.
Yes.
Clarification from UGC is still awaited, Your Lordship.
My lord, in this case, Lordship, my lord, so far that scheme of 1993, my lord, which speaks about, my lord, temporary status, then regularization against Group D post. Now, after 6th Pay Commission, my lord, Group D post has been redesignated as Group C post with revised, my lord, qualification with higher pay scale. Now, because of this situation, we are unable to do, and we sent a letter to UGC, my lord. We have not received any reply. So last time my learned friend said that, my lord, UGC has nothing to do. In fact, my lord, UGC has extended this. This is the letter. All these schemes and all, we cannot just enforce the scheme, my lord, unless it is, my lord,
mandated.
Extended by 97, they have done it. Everything is here. So, my lord, UGC, my lord, whatever UGC say, we will do it.
Your Lordship, I covered clarification. The Commission has agreed to extend the benefits, and I would like to put in record, if I'm not mistaken, my learned counsel has submitted the same.
This is same thing.
This was extended in 1998, my lord. Has also been agreed that the benefits should be extended.
Data.
Yes, it is. In fact, it is merger of Group D, merger with the Group C, and now they are designated as multitasking staff. And as per this letter, Your Lordship, it is effective from 29 August 2008.
Which letter?
97.
Let's see what.
Yes. Para 2.
This is not the same letter I have. Oh, this is 2013 letter. You didn't give this 2013.
Yes. And para 2, I read it. The issue has been examined, taking into account the department's number so and so with regard to fixation of seniority.
Where did you take it out from?
I got it from my file, Your Lordship. Quite old file.
What is this?
And with regard to
Take
fixation.
out a paper from your pocket and give it for
No, no, it is not in my pocket, Your Lordship. I'll bring it on record. I'll bring it on record.
That is from Ministry of Personnel.
Yeah, that is totally different. This is regarding multitasking staff in.
That is with regard to merger and redesignation.
It might have some impact.
Yeah.
In Personal Recommendation 6 Central Pay Commission, the department issued model recruitment rules for the post of so and so of erstwhile Group D post. Now
it will be.
This is Lordship will
This merger will be.
Department, not from UGC.
My point is this merger will be effective from 29 August, Your Lordship. Yeah.
Because they are governed by whatever the UGC directs. Correct?
Yes.
So what is this?
This is the date of merger. That is, merger will be effective from 29th August. That is the only point here.
You're confusing the court now.
It has been decided that the merger and redesignation of elsewhere Group D staff, multitasking staff shall be effective from 29 August 2008. The date is important, Your Lordship, here, the date of merger.
Not really. You were appointed for 93?
Yes, from 93. Yes.
What do you have to say about this document, 1997?
Yes, this is, they have approved this. They have accepted
So you
the
say
scheme.
that even under the scheme must be entitled to realization?
Yes, we are entitled, Your Lordship, as per the scheme. After grant of temporary status, the next benefit as per the scheme is regularization of service, Your Lordship.
Yes, Mr. Sen.
We are not denying that, my lord. But in the meantime, what happened, my lord? 2008, after 6 pay commission, Group D post has been redesignated as Group D with higher pay scale and revised qualification. They do not have this revised. Unless UGC relax or UGC give us some direction, my lord, we are unable to.
This what's produced today has no relevance. It just says that yes, the scheme was extended in 1993.
Exactly, because the last time.
Where's the other? What other clarification is got?
Your Lordship, it said that you would agree on it. You would agree to extend the benefits of it. But the main emphasis has to be laid on NEHU because the whole procedure has been taken forth by NEHU because they are.
Well, of course, but now the case that they are not qualified for,
exactly.
then they've been relegated to multitasking. What is the condition now?
Condition now, my lord. This is annex, my lord. This after redesignation, my lord. What are the qualifications? Affidavit, university.
So for this,
kindly come to our affidavit, my lord.
We're getting nowhere.
Page 12, my lord, of the Nehu affidavit.
Now, why do you write to the Ministry of Personnel yourself?
Ministry we have written, my lord.
Why? Then if we have produced, with regard this, you've seen this OM dated 2013?
Yes.
You've seen this? Effective date, yes. Yes.
Our affidavit.
So the thing is that how many of you passed class 10?
actually, none have passed class 10, your lordship.
That's the problem.
Yes. Only one is a graduate, and so far the scheme is concerned.
So now you've
that is only in the Uma Devi case.
Multitasking and pay daily wages.
No. Yeah, my lord, pro rata.
I mean, they're just related to multitasking with no other service benefits or any.
No, whatever under the scheme they are getting, my lord, including the pay.
So regularization will be under the scheme.
Only thing now remain, my lord, regularization. But because of this problem, my lord, Group D has been redesignated, my lord. That's why, my lord, what we did, we wrote to the UGC. They are silent over it. What my learned friends say is they want to extend it. How they will extend it, my lord, with the modalities if they write to us. So my humble submission, my lord.
That exactly is the situation.
Yes, my lord.
Now they've been serving for over 30 years, correct?
Yes.
30 years. Now, they, by all rights, they should have been given benefits of a higher pay scale from Group C employees, but by virtue of their lack of qualifications, see, they are being deprived or whatever, you know. I mean, it's a real degradation in the service. Then instead of Group B, now the Group is gone. They've been given to.
We are unable to process, my lord.
That is the thing.
So only thing, my lord, we have written it to the UGC, my lord. If your lordship close the matter with a direction to the UGC, my lord, to respond and give us the necessary.
Have you filed affidavit here?
Yes, Your Lordship.
No, even that won't solve anything because they're left high and dry.
Lordship, our letter to the UGC, my lord, at page 8. This is addressed to the Government of India Ministry with a copy to the UGC. So far the ministry is concerned, they communicated. So far this scheme is concerned, this is not applicable to the now. Obviously, I understood, my lord. These normally do not apply. But UGC has extended it. I have just placed this letter. So now UGC will have to take a call. How to go about it, my lord. Nehu of its own cannot take an independent decision. Neither we can relax, my lord.
Because you've designated.
Nehu is an autonomous body, your lordship.
Relax the class 10.
No,
Why?
We cannot, my lord. Because, my lord, so
per
far, my
DOPT.
lord, teaching, non-teaching stuff, everything, my lord, these instructions come from the UGC.
No. This is as per the recommendation of the 6th Pay Commission and given by the Department of Personnel and training, whatever. This qualification that if they are to be taken in Group C, that whatever pay band, they have to have the class 10 qualification, correct? Yes. And these people don't have it. Now, how do you address the situation? They've been serving more than 30 years. Their Group D post is gone. Then what happened to them?
That is why, my lord, this is a situation.
Giving direction of UGC will not solve the issue. Then because the thing is that because the directions for this criteria or minimum qualifications given by the 6th Pay Commission and the recommendations accepted by the Department of Personnel. So where does it leave them then?
Under my humble submission, my lord, if I can put it one way, my lordship, there are two kind of employees, my lord.
Can you accommodate them in some other, what do you call it, capacity?
But there has to for
how many of you are there?
There has 30 ladies.
30 years.
You can't think of that.
There has to be a sanction post.
No, whatever sanction, whatever, it has to be something. But you can't. What's happened to them? See,
I understand.
Instead of their services being upgraded, it's been downgraded.
I understand. My humble submission, my lord,
how will the court look at this?
UGC, because these will have a financial implications. Now the budget comes from where? It's come from a UGC.
Whatever it is, finance and the sanctions,
these will have a financial
comes later. But how are you going to treat these people?
That's where, my lord, I don't know.
Whether UGC can even issue directions over and above the what has come from the Department of Personnel.
Yes,
they can't.
Yes.
They can.
No, my lord. No. I'm just coming. That's why what, my lord, teachers. When the teachers comes, my lord, normally the revision of pay scale of the teacher, how it is done, my lord, following central pay revision. Now that is not applicable to the university, my lord, Sumoto. What the UGC immediately takes away independent exercise, my lord, in concentration with Ministry of Finance, and then they extend it. It is always the UGC extended, my lord. We have done a number of cases, my lord. It is the UGC who extend. Nobody else can extend it to the university.
My lord, in my stance, I just want to clear the stance from UGC. UGC has made it very clear. We may give our recommendations, but the ball is in Nehu, whether they will take it or not.
No, what ball is Nehu? They are governed by your whatever you direct. And now, if you have given that in class 10, this is given by, okay. If you say that they can be given a go by, they'll give a go by. Then give them group C accreditation, whatever.
If relaxation is permissible, if they say relax one time relaxation and accommodate them, we have no problem.
Come with correct instructions then.
Your Lordship, they have stressed on the fact that even if they wanted to recommend anything, Nehu is an autonomous body. They cannot play part in the procedure of how to recruit and how to go about it.
It's not a question of recruitment, it's a question of how to address the situation.
Your Lordship, as I've stated before, we have given our recommendation to extend the benefits. But in the end, the ballpark is in Nehu, whether they accept it or not.
It's not the ballpark. The question extend the benefits, but if it's not reaching them. The scheme, extend the scheme well and good. But what does the scheme say? It calls for merger of Group C, Group D posts, and by your prescription of eligibility as given in this notification, they fall outside that. They fall outside the net.
Your Lordship, UGC is not willing to give the clarification between Group C and Group D because it doesn't pertain them. That is what this attorney, with the Director of Personnel and Training, can shed some light on it.
Is Union a party here? Yes, but they have not shed some light.
Your Lordship, in this matter, when this ministry is issuing this notification, and it is for the central government employee, and it is the autonomous body. So, if the autonomous body is taking this notification, memorandum issued by the central government, and it is in between with them, this department.
No, see, the scheme extended, 93 schemes extended by UGC to the university. It's been adopted, correct? But extension of the scheme has resulted in the degradation of their service.
So, in this situation, Your Lordship, when this office memorandum, if they are accepting and adopting this, then ultimately this next notification, if they are adopting, the same criteria will be adopted by this university.
That's what just left them out from the having any benefits of
Your Lordship, in this matter for the casual laborers, when these matters come up, even earlier matters, central access customs, and then in these matters, when I have given this opinion that they are not having the requisite qualification, but I was saying on this angle that if this person is not having this qualification at the moment, and earlier he was working, and then in such situation, this
allow him to do class 10. How?
No, they should not be stagnant.
Yes.
They should not be stagnant. So their qualification will be considered because they are continuing in the said post. And this merger of the post, ultimately, it is not removing to them.
A very funny situation.
So far, my lord, these temporary status employees are concerned, they are not holding any sanctioned post. Without any post.
Doesn't matter, but they should get the benefits of whatever.
Exactly, my lord.
That's the only thing.
No, my lord, exactly.
Why should we pay pro rata?
But then here, my lord, Lordship will see, my lord, Central University, my lord, and UGC Act. Today, I don't have.
In other universities, how is it done?
Same, my lord. So far, Central Universities, my lord. Central University, we are dependent on our UGC. We cannot fill up any post, my lord, by granting relaxation without the intervention of the UGC. It is the UGC, my lord.
That's not hearing.
This is a situation, my lord, the call has to be taken by the UGC. Because Lordship is aware, my lord, these teachers. All qualification prescribed by whom, my lord? UGC, my lord. We cannot relax. We will have to follow. Non-teaching also, my lord, by the UGC. So, my lord, my humble submission, my lord, we have written to them where they are sitting over it, my lord. If they dispose of this letter, my lord, certain instruction. My lord, our letter is that affidavit, Nehu affidavit, page 8. (6023) Annex 1.
You've written to UGC, you've written to.
Well, written to with a copy to UGC. Well, we have received a reply from the personnel department. They very correctly they said, so far this scheme is concerned, this is not applicable to Central University. This is for the government department. True, my lord. But it has been extended to us by the UGC. So we have given a copy to the UGC, my lord. Reply should come from the UGC.
Because they should have been eligible, for aeration if they've been upgraded to Group C posts. Right? Yes, sir. Take down. The counsel for the UGC is respondent number 3 has produced a communication dated. Dated what?
Dated, my lord, this 22nd April 98.
22nd April?
Yes.
1998.
97.
No, 1998.
Dated 22nd April 1980, which is taken on record. The said notification is with regard to the subject of grant of temporary status and regularization of casual laborers in Central University. It is seen that by this communication, it is seen that with its subject matter, with the concerned subject matter, the casual laborers, stung inverted commas, then bracket grant of temporary status and regularization, close bracket, scheme of Government of India 1993, close inverted commas, issued by the Government of India, DOPT, has been extended to the casual laborers of central universities. Stop. Next paragraph. Mr. S. Sen, appearing for the university respondent Nehu, has submitted that in this context, with regard to the service of the writ petitioners, a letter had been sent to the Ministry of Ministry of Personnel, to the DOPT Ministry on 6/2/2023, seeking clarification on regularization of temporary status casual laborers working in university. So, he submits that the reply received from the ministry was the reply.
Just see. Well, after filing this, I'm just pleasing. This is the reply. Oh, yes, in her affidavit. UGC affidavit. It was there in the UGC affidavit. Please.
Where's the reply? Oh, no.
It is there, see this letter.
Which reply says that since
this is a central university, my lord, this will apply to the central department, not to central.
Yes, reply that the sense that as the respondent University Central University, the same will apply only to the ministry itself and not to the central universities. It is further submitted that as the mandate of UGC is applicable in as much as even the extension of the scheme has on UGC, any further action in this regard will be subject to clarifications and direction received from the UGC. So, next part, S. Langstay, Counsel for UGC. What's your submission? That the scheme has been, since the scheme been extended, it is the Nehu respondents. It is the university who should take a call on the matter with regard to the services of the casual laborers. This court notes that with the introduction of the scheme and its implementation, of the Group D posts have since been eliminated, whereby person 7 Group D have been accommodated in Group C, and the graduation considered in in that regard. Stop. However, with the prescription of what's the lecture regarding the requirements qualification.
It is
However, with the
affidavit, Your Lordships.
however, it is seen as per the however it's seen that due to the model recruitment rules for Group C posts, the petitioners who are not 10th pass will be kept outside the ambit. Stop. The situation that has resulted is such that the petitioners were serving Group D posts. They were serving Group D posts, correct?
No.
Who are temporary, sorry.
They are purely, my lord, without any post.
Who are casual.
With temporary status.
Temporary status can be considered for accommodation against Group D posts since it has been eliminated, and also are not eligible for Group C posts. Stop. This code therefore seeks is direct for clarification to be provided by the UGC, who have given the scheme to the Central universities. What should we say? What clarification you want to ask?
Regarding, my lord, the qualification and whether they can be accommodated in Group C.
Yes. Clarification as to whether from the UGC also respondent as to what will be this as to whether the petitioners as to the requirement can be relaxed to allow their accommodation in Group C posts. Stop. Copy of this order is to be supplied to the respondent number 3 for on communication and for necessary clarification. Yes. Just after vacation.
This remains pending, man.
Yes.
Yes.
Okay.
19.
No time today, MS Cloud.
This matter was about to dispose of, my lord, in the last occasion with regard to the small instruction from the petitioner side.
Lordship will do on the next day, next week.
You want to withdraw?
Lordship, no. Lordship, as far as
Matter
their
will be disposed of, my lord, because the
Lordship, as far as their submission, they said that we should approach to the appropriate authority, but the inquiry report have been submitted after 195
that
days.
is not our submission, my lord.
No. You have submitted that we have to approach the appropriate authority for inquiry for the complaint of the inquiry report on the last occasion they have submitted. Since they have given us the inquiry report after the expiry of 15 days, which is any complaint to be complained before the concerned authority, we have to give the complaint within 15 days. But they have given us the inquiry report after 195 days.
My lord, that was not our submission, my lord. During the course of the hearing, my lord, she wants the.
No, you asked for setting aside inquiry report, that's all.
Yes, she.
Let them consider it then.
My lord,
for setting aside.
Then the council may argue.
Lordship, Lordship, why I am pointing out this is that, Lordship, in the inquiry report, there are many errors. One of them, I just want to point it out. In their inquiry report, in column 30, I'll give the annexure page later, they have said that these are entered only in MIS, but the work demand has not been given. As the RTI report we receive, the job demand has also given, the fund has also been released, and the voucher has also been given in the
discrepancies in inquiry report.
Yes, Lordship.
Has been conducted, my lord.
Yes, Lordship. They should approach the appellate
my lord,
authority, Your Lordship.
No, he's saying that anyway, we'll have it. When do we have it? Today is Tuesday.
Next week, Lordship.
Tuesday, my lord.
Next week is
my lord.
Also for hearing on so and so.
29.
Today, because we have to go for inspection, the 2 o'clock is a problem.
Yes, my lord. Okay. Oblige, my lord.
File additional affidavit.
Yes, Your Lordship. We have filed
What's the
a
additional
petition
affidavit say?
But there is a
Now, we
record.
are saying that B.Ed is a mandatory
No.
qualification for a post of assistant headmaster. You know.
But that rule is not applicable in deficit school. Your Lordship can.
That
Going
is-
back to Assam, Assam
He is going back to that, but we have got our.
Because that Your
The
Lordship kindly tells
NCT
that.
is mandatory, Your Lordship.
That rule is 2012 it only for recognition, only for new school. For permission and opening. Your Lordship. That rule, Your Lordship, that annex, page 6, an additional
We
affidavit.
filed this yesterday, Your Lordship.
Where is that?
We have attached the regulation,
Where is
also
that?
which was enacted by the government.
2012.
Yes. Annexure 2, Your Lordship, page 6.
Yeah.
Your Lordship, this was on the basis of the powers conferred by Section 31(1) of the Meghalaya School Education Act. The Governor of Meghalaya has
So which is the applicable one?
number 16. At 16, Your Lordship, it says that assistant head of the institution and qualifications. There shall be an assistant head to assist the head of institution on all matters relating to the administration of a school. She shall have a minimum qualification of bachelor's degree with B.Ed and with consistent good academic record, Your Lordship. So, Your Lordship, it is mandatory now. Even that letter dated.
When was it implemented?
This was with effect from 14 January.
Where do you see it from new schools only? Where?
I'm paper 1988.
Where does it say in this rule that's only for new schools?
Yes, Your Lordship. For ministerial, in exercise of our conversion, so we make the following recognition rules for recognition of secondary. Page number 6. Annexure 2.
No,
the governor pleased to make the following rules for recognition of secondary higher for recognition only. And short idea, these rules may call recognition of school. And now Your Lordship turn to page 7.
For recognition of secondary and higher secondary schools, and it is
page 7
for all schools.
Clause 3. Recruitment for schools and obtain permission. So and so open new schools, secondary school, high school shall need to obtain.
Different.
This is some different, Your Lordship. This is only for permission,
recognition,
not for qualification. We are on the qualification
this
of a
rule
teacher,
is
Your
not
Lordship.
applicable to. It is not service. It is for the only for recognition of the establishing a new school.
I think my
Requirement
friend
of
has
obtain permission.
misconstrued the entire thing, Your Lordship.
Provisional recognition of secondary school. All secondary school high school may apply the prescribed format.
Even the National Council of Teacher
That
Education has
permanent-
made it mandatory that all teachers should be a B.Ed. Otherwise, their appointment will not be approved by the government, Your Lordship. And this was passed in
Clause 5,
2001,
permanent
Your
recognition
Lordship.
of secondary school. Permanent
Then
recognition will be
again,
accorded
in
after registration
2007
completely fulfill Your Lordship. Pursuit of recognition. Clause 6. On receipt of application, director shall inspect the school and after then filed by recognition. And
You file a short rejoinder.
I have already in my reply, I already said that it is not applicable.
The National Council
And
of
they
Teacher
also tried
Education
to
is
list
That if now the mandate is there, it becomes very difficult.
Very good.
We
You cannot.
Because I don't have time today, sorry. Yes.
30.
Yes, well, also, so yes, an additional effort has been filed yesterday itself. I'll have to look at it also.
Yes, Your Lordship.
Has been filed on, has been filed yesterday. Stop. Just a matter for further hearing on. You take the date.
Next clarification any day.
Yes.
God bless you.
Only that part. Whether what rules are applicable. Yes. What miscase is this?
Filed a short miscase, Lordship, to allow us to file a rejoinder which was closed on the last date. My rejoinder is ready, Lordship. It can be filed in the course of today. Lordship, he could, because the petitioner was he is on a pacemaker, he could not come to sign. Unfortunately, it was not.
Miscase
brought to the
number
notice.
296/2025. Stop. This is an application for recall of order dated 12/11/2025, whereby the filing of rejoinder has been closed. Stop. Mr. S. Dev submits that the non-final rejoinder was due to the fact that the deponent was very unwell. You don't object?
No objection.
The prayer for final rejoinder objected by counsel for the petitioner or respondent. Sorry. Accordingly, the prayer is allowed. This case disposed of. In the main case, with the order passed also, the petitioner is going to file rejoinder within 1 week.
To 1 week.
This after vacations for hearing.
Much obliged.
Obliged, Lordship.